Good afternoon. We will now start with panel number 3, Electoral Justice when facing new challenges of money in politics. No, sorry, I apologize. That was the previous one. Just give me a second, please. I mixed the pages up. I apologize. We will now start with panel number 3, Electoral Justice, regarding customs and traditions or indigenous customary law. I will now introduce the panel members. We have Magistrate Carmen Duña Sandoval Arenas, member of the Electoral Supreme Tribunal of Bolivia, and Magistrate Enrique Figueroa, who is a magistrate of the Electoral Tribunal of the Federal Judiciary. Please go ahead. Thank you very much, Mara. Good afternoon, everyone. It is an honor for me, a pleasure, to be here this afternoon and to resume our activities for this 9th Ibero-American conference here in San Miguel de Allende, Mexico. I would also like to thank the presence of our guests from South Korea that just arrived here this afternoon. Welcome. And one of the main topics of the agenda for electoral justice in Ibero-America is, without a doubt, has to do with indigenous peoples and communities. And I'm sure you will ask yourselves, why is the moderator saying this? In the case of Mexico, the Electoral Tribunal of the Federal Judiciary has a higher chamber and 6 regional chambers. I am part of the regional chamber of Jalapa of the Electoral Tribunal, which is based out of Jalapa, Veracruz, that participates in, has jurisdiction in 7 states of the country: Veracruz, Tabasco, Campeche, Yucatan, Quintana Roo, where Cancun is located. We also have Chiapas and Oaxaca. As you already know, the state of Oaxaca especially has 570 municipalities, and 417 out of those, they renew their municipal authorities using their own internal systems. I would like to thank Janine Otarora and the magistrates José Luis Vargas Valdés, Felipe Pizaña, Mónica Soto Fregoso, Felipe Fuentes Barrera, and of course Mr. Infante. Thank you. I would like to thank you for allowing me the opportunity for chairing this session, this panel. Of course, thanking Carmen Duña for her company here. You might already know that, unfortunately, the representation from the Electoral Tribunal of Ecuador wasn't able to get here, but I'm sure we will be able to share many experiences here from the From Mexico. I have a dear friend, Magistrate Juan Carlos Silvadaya, who has vast experience, and I'm sure he will be able to share some of this experience. But now, to start talking about the topic in hand. Starting on 2001, this has played a very important role, and I'm talking about indigenous customary law, because in that year, in Article 2 of the Constitution, we included the fact that it is a pluricultural country, going above the integrational and assimilation policies that had been prospering the last few decades, that of course were based on the postulate that indigenous peoples and communities had to incorporate themselves, had to incorporate themselves in the Western culture. But now there is an acknowledgement that Mexico is a pluricultural or multicultural country, and that must respect and protect our native peoples and communities. So along these lines, we already know that in our continent, in the Americas, there's very important background in the Inter-American Court of Human Rights, Yatama versus Nicaragua, or also Paraguay was sued regarding the possession and the use of their land and natural resources. So I think that this topic gives us the opportunity of examining which new topics have been added to the work of the electoral tribunals in Ibero-America. So I would like to start by listening to the opinion of Carmen Dunia, so she can tell us about the experience from Bolivia. Thank you very much. Well, first of all, thank you for the invitation. We are 7 members of the Supreme Electoral Tribunal, and we, 2 of us wanted to come here. One of them was unable to get here. Idelfonso Mamani was here in the last event. He is an indigenous member, and he was in the last meeting in Manaus. We have an event on December the 3rd. We will have judicial elections, and this is why he wasn't able to come here. Well, in 2003, there was popular riot, and Gonzalo Sanchez de Lozada was removed from office. There were 2 interim presidents, and in 2006, Evo Morales took office. But upon requests for a transformation that was given, took place between 2007 and 2009, that's why the Constitution was amended. And there are 2 very important things that were amended: the incorporation of the collective rights of the indigenous peoples, and also the parity when it comes to institutional or public office between men and women. So what is the participation of indigenous people directly as a result of this new constitution? Well, first, people can choose representatives by their own customs and traditions or indigenous customary law for the department level assemblies. We have 9 departments, and in each department, based on the number of important indigenous peoples, each department level assembly has determined which of them will go in directly as assembly members. So out of each jurisdiction in the legislative branch, we have these people, and we have 15 out of 187. So, for instance, in La Paz, out of 45, 5 are indigenous. In Santa Cruz, 25 out of 28. Cochabamba, there are 2 indigenous representatives, and so on. But this is not given based on the number of the people, of the population, but based on a collective representation of the peoples. But I want to clarify something. There are 2 main groups. They're not really minorities. I wouldn't call them minorities. But they both together represent close to 48% of the population. They are the Aymara and the Quechua groups. So there is a high self-identity levels, and in the census, they are majoritarian peoples. This is why they don't have a specific indigenous representation. But the other 34 groups do have them, which would be considered minorities, which are most of them in the Amazon part of Bolivia. So they participate in 2 ways: in department level assemblies and also in the national parliament, which is called plurinational legislative chamber. 7 representatives for indigenous rights, only 7, and we had to have 36, but there was a political negotiation, and they landed on that number 7. But those 7 represent their people. So you have an idea. There are 2 Guaranis, 1 Mosetén, 1 Secure, 1 Cabineño, 1 Uru, and 1 from the people of Cochabamba. So there is an acknowledgement of these facts and the practice of these collective rights, because the representation, it's not just one citizen, one vote, but one representative for the group of people, even if it's a small group. For the ones that opposed to this inclusion, they thought this was too much, and for the ones that want us to abide by the Constitution, they would like to have all the 36 representatives and not only 7. So it is a progress that has been made. Another means of participation is through indigenous autonomies. A municipality can transfer or can be turned into an indigenous community through a referendum where all the inhabitants of the municipality decide whether they want to become a territory that is indigenous, that has autonomy because of the indigenous people. But that is hard because there are no municipalities that have just one group. There are migrants, for instance, from the Andes region. They migrate a lot towards the tropics, the lowlands of Bolivia, and they mix, so they negotiate with the other group so they can, let's say, win this referendum. So there are 11 communities that have decided to become indigenous autonomies, but it's not that easy because there is a series of legal steps that have to be taken. It's not something that's automatic, and after several processes, only 2 of them are in force and are current. There is a Guarani indigenous autonomy in the zone of Charagua that already created its self-government, and in Uruchipaya, next to the Titicaca Lake. And that one started in the first week of January 2018, will start in the first week of January in 2018. And some others are in the process, but they still need to take some steps. There are 2 referendums that are made. One to decide whether they want or not to be an indigenous autonomy, and the second one to approve their statutes or bylaws. And this is what's interesting, because in order to draft the bylaws, they have to forge pacts with other, or agreements with other kinds of people, with other groups. And this means, in our Bolivian experience, is that they are not ghetto-type indigenous autonomies, but they choose their authorities and they appoint them by with their own procedures. For instance, there is no mayor anymore. Instead of a mayor, they can have a major captain or a council of captains, in the case of Guarani, which are called murubichas, or also a double authority, such as in the case of the Andes, which is mama and tata, which is like the mom and the dad, the couple, that take that role, and there are also assembly members. So in general, we have recommended that they have 2 bodies, such as councils or boards. However, they don't have the same the composition in all municipalities. This is why they do it with their own standards and procedures. And another interesting thing is that they are still citizens of Bolivia, and they have the possibility still of participating in the representative democracy. I should have said this at the beginning, and this is just my closing comment. We have intercultural democracy, which is comprised of representative democracy, with a vote that with which we elect our representatives, and we also have the direct democracy, which is the direct opinion of the citizens, and the most common example is a referendum. Each citizen provides his or her opinion through a yes or a no, and not through the representatives, but directly. And we also have community-based democracy, which is the one that is enforced by these indigenous peoples, that they can elect their representatives. And I would like to repeat this case: the assembly member at a department level, if they are indigenous, they are not elected, but they are, let's say, chosen by the community with their own rules, not with our rules. And the same thing happens for the representatives, for the House of Representatives that are appointed by the people. So it is a democracy with various different levels, not only for election by a vote, but for instance in judicial elections, all citizens participate by voting, with no exception, even including also indigenous people. So this is a process that is, let's say, in progress. It is very interesting, and it is taking a lot longer than we thought at the beginning, but we have made progress, and the proof of this progress is that we have at least been able to consolidate two indigenous autonomy regime. Just one more thing, if you will, please. This is mixed with parity or equality, because, for instance, the Supreme Electoral Tribunal, I know that some are made up of lawyers, but for our Electoral Tribunal, each person, there is a public invitation published in the newspapers. People don't need to be lawyers, and they can run for that position, and it has to have at least 3 women. There's a total of 7 members, and 2 indigenous representatives as a minimum. Of course, these indigenous people, it cannot be just any person. They have to be highly educated and trained people that meet the same requirements, and that it's a merit-based appointment based on their professional experience, their academic record. There's a test that is presented before a tribunal regarding the laws and the Constitution, and then they are elected by 2/3 of Congress, by voting in Congress. But by doing this, we have the highly prepared indigenous people and highly prepared or highly skilled women, and also men. They can have access to these courts or tribunals, and they can be part of the electoral judiciary that meets. You can think it's right or it's wrong, but it gathers all the functions, jurisdiction-wise, and also for the administration of the processes. So to conclude, the plurinational state or multinational state of Bolivia has made some progress that is already enacted in the Constitution, and we cannot really go back because they are acquired rights and they go beyond any leader or any political party. These are social wins of sectors that were excluded previously. Thank you very much. Thank you very much, Carmen. It's very interesting what you talked about, because, among other things, for the Bolivian population, the indigenous communities play a very important role in the integration of your people. So as you can see, based on the main topic of this panel, if Mr. Jose Luis Vargas doesn't disagree with me, I would just like to share with you some experiences of the Mexican case from the standpoint of the Regional Chamber of Jalapa. But I would like to make some statements before that will provide some context. Well, I know, like American Professor Alf Rhodes said, that democracy is the supra-ideology of our times, but democracy is seen from different cosmovisions, or from different points of view, and without a doubt, the indigenous peoples and communities in Ibero-America represent that. So, like I was saying at the beginning of this panel, the electoral reform, the constitutional electoral reform of 2001 included in Article 2 of the Constitution the indication that Mexico is a multicultural nation, highlighting that we must safe keep and protect the autonomy, self-determination, but also there's a very clear statement that human rights must be protected and respected, and especially the rights of indigenous women. So the Supreme Court of Justice of Mexico and the Electoral Tribunal of the Federal Judiciary have set forth a series of instruments that, together with the juridical methodology, allow us to address topics such as complex as these. And I am talking about the protocols to resolve matters with a multicultural perspective or with gender-based perspective, to address political violence against women that has become part of the Mexico legal framework. I would also like to clarify that in the case of Mexico, the indigenous peoples and communities have to go through three different discussion levels at different levels. If you will allow me, I will take as reference one of the states in Mexico, the state of Oaxaca. There is an electoral tribunal of the state of Oaxaca. Then the rulings that are ruled by this tribunal, if it has to do with the city halls, they can be reviewed by the Regional Chamber of Jalapa, and then that ruling can be reviewed lastly by the High Chamber of the Electoral Tribunal of the Federal Judiciary. So as you can imagine, this allows us to have a jurisprudence dialogue that's very intense, that allows us to review these matters from different points of view, and of course trying to cover all the points of view of these people that are members of these indigenous communities. Mexico has has a lot of experience in this. I would like Magistrate Juan Carlos Ibadaya to share one of the experiences, because he's one of the pioneers when it comes to this. But if you will allow me, I will just talk about some of these points, of course abiding by the time limits that we have. Very quickly. Right now, the indigenous peoples and communities in Mexico are bringing to our offices very important and sensitive topics. In the case of Oaxaca, there is the phenomenon that municipal agencies did not participate in the election of the municipal authorities. This was addressed in all these three discussion levels that I mentioned before, and right now there is a consensus that by observing the culture, the customs and traditions, there must be this kind of division. The agencies mustn't intervene or participate when electing the head of the mayor, or the municipal president. And also in certain cases, we must use anthropological expert opinions as an instrument that can be used in order to know if that is really part of their tradition, of their customs, or if we really are facing a case of mere convenience. Something else that we are facing very often is the impact or violation or breach of the rights of indigenous women. You can see that this is cross-sectional, because in the case of indigenous peoples and communities, the political participation of women is highly affected. So the regional chambers of the federal judiciary has focused on trying to balance the opportunity so that women can eventually not only vote, but also run for office. Another important thing that has gotten to our desks and our offices have to do with the possibility of that population, that people that has been migrating to the capital cities. In the case of the state of Oaxaca, the municipality of San Sebastián Tutla, whose municipal authorities are renewed by their own methods. It's now part of the metropolitan area of the capital city of the state. And now the majority of the people who live in San Sebastián Tutla, they work in the capital city and they only go to sleep in that municipality. And of course, it's people that don't identify themselves with those with the methods of that municipality. So they wanted to participate by that in that, but by using political parties the regular way most municipalities have been doing so. Another very interesting thing that is also a concern now is that indigenous peoples and communities, they consider that they have the right to directly manage their financial and economic resources and not depend in any way or rely on the municipal government. And based on Article 2 of the Constitution and on the constitutional block that oversees indigenous people. And I would like to highlight that in the Americas last year, the Universal Declaration of the Human Rights of Indigenous People has been enacted. And now their economic resources, they say they must not be managed by the municipal government, but directly by the agencies. And lastly, political violence is not only against women, it's not only not only translate into them being candidates and being harassed or giving an unfair treatment. But once they already hold office, they also face obstacles and hindrances from their male counterparts. And we have seen that the only thing that is different is, of course, that they are women, and that continues to be an obstacle. And by saying this, I hope I very quickly provided some context of electoral justice in Mexico. Of course, it is something that, as you all well know, in the Electoral Tribunal of Mexico, it is part of the core of the agenda of our tribunal. This is why, since 2016, the Electoral Tribunal created the Ombudsman Office for the indigenous people that has at the core of its activities facilitating the access to electoral justice for these people. And from the policies of the Electoral Tribunal, it goes hand in hand with access to electoral justice, like I said before. So this is what I just wanted to say like I said before, to provide some context of the Mexican case. And now I would like to open up the floor to listen to the very valuable and expert opinions of the people, the attendees. Who would like to participate? Please, let's thank him with an applause.
Uruguay, please. Thank you very much. First of all, I would like to congratulate you for your speeches and your participation, and I'm going to make two questions. The first one has to do with the historical process, and I would like to ask you for your evaluation or appraisal. The agreements of San Andrés La Raiza had to do with the constitutional change and then the development of all these events that you are describing. That's it's a historical data. And the second one, I have a question. In one municipality, can we have two different governments? The municipal government and the other one? And how do you solve these disputes in case there are some? The second question is for both of you. The first one is for him, but the second one is for both of you, please. Okay. In Mexico, we are a country with 120 million inhabitants, out of which we have lots of figures that have been mentioned depending on the criterion that you follow in order to identify the indigenous people. And the variation is between 7 and 12 million people. Indigenous people. We have identified up to date 68 indigenous peoples, approximately with more than 340 variables in their native tongues. This is on the one hand. Now, within this plan or scheme of the national or the country that we live on, we can identify two types of systems, which is political participation and indigenous government. One that could be identified as the autochthonous or the originary, which is the model of the case of Oaxaca, so that we have mentioned already that out of 570 municipalities, 417 approximately are the ones who determine the procedure, the positions, and everything, and times. 1 year, 3 years at the maximum, 2 years, 1.5 years of the duration of the position. Also, we can have the position syncretically. We don't only elect political charges, but also religious ones. So in this model, we can locate other cases, like, for example, what we can identify as those that are coming as a result of the riots, like, for example, the Cherán, who in Oaxaca. There is another one in Guerrero, where what we have regulated, because let me tell you that this is a subject matter that is regulated per state, I mean in a state-by-state basis. And they are compelled to regulate this in the local constitutions or in the secondary legislation. So they receive all these models, okay? So there was a case of Cherán where there wasn't such a developed model like in the case of Oaxaca. So the community, by exercising the rights of having a free determination in Article number 1, I mean, these experiences can be good for to find solutions based on the international treaties, besides the Covenant 169 of the Work Trade Organization and the indigenous peoples. They acknowledge this right of self-determining and to configure, to form the procedure and the nature and the characteristics of the municipal authorities. So, through a decree of the High Chamber and before the denial of the authorities to acknowledge that right, they denied to develop even at an institute level what we can identify as a Praetorian right, through the determination or through these rulings that conform the scheme. So that's one of the models. And the other model that we can identify as affirmative actions or integration-wise, without forcing the assimilation. And that has to do with all those other authorities, in this case, the case of Sonora, where there is a structure of the city hall with the chair and other the official receiver, the liquidator, etc., etc. And in the case of the state of Hidalgo, when they make the division of the districts for the legislature of the state, 3 of the districts are indigenous. Or in the case of the division by districts made by the Electoral Federal Institute in order to elect the representatives, due to this principle of relative majority, there are also indigenous representatives according to the majority of the population. But let's say that this is the model of the Western democracy, which is individualist and liberal, where there are a series of compositions in order precisely to receive the representation of the indigenous peoples. And there have been other cases that we can mention. So these are the 2 big models. For example, in the case of the state of Mexico, when we elect the municipal authorities, in a parallel manner, we also elect the indigenous representative, which is provided by the federal law as an obligation, as a liability, to provide these indigenous representations. But this fills within this mold of this instrumental democracy, where we set out these figures in order to acknowledge this right. And finally, to conclude, the fact of other initiatives, which was mentioned by Mr. Chair of this panel, where their own communities are claiming to manage the resources, the public resources. And this is a message precisely for the case of the political parties. There are other city halls where, in the case, for example, of the state of Michoacán, there are some other city councils or local governments where they do carry out the elections by this regime of political parties. Nevertheless, their own communities set out some variables. For example, there is one community in Michoacán, as far as I remember, where it's not allowed to carry out campaigns for the political parties, but only one day. And this is kind of a community meeting, open community meeting, and all the candidates go there and they talk about their plans and programs, but only once, one time. Thank you very much. Thank you very much, Juan Carlos. Mr. Magistrate José Luis Vargas. I don't know if somebody else wants to make any comment, so that Mexico is not the only one speaking. Yes, please, Panama. I would like to share with you our experience in Panama with indigenous peoples. We have 5 districts in Panama. We have one that is very big, which is the district Nove Buble, and they are areas of 3 different provinces. And this is a very wealthy land in water, copper, etc. So the Electoral Tribunal has been doing the traditional election process. And obviously, in the general elections, they also vote, and they are also candidates. We have some representatives that are elected by region, and the tribunal has been doing these elections because at the beginning they were very conflictive, and so they asked us for some help, and we have been supporting them the most we can. And in fact, currently, the one who chairs, the maximum authority is a woman, Mrs. Silvia Carrera. She was elected. At the beginning of the next year, we are going to have a new election in this region. And for us, this has been a great experience because we see that everyone is creating awareness of the indigenous needs. Sometimes they are relegated, they don't have the minimum resources regarding education, health, etc., even though they are so wealthy. We see that the government is there sometimes because they are interested in obtaining something. Like, for example, if they are going to install a hydroelectrical company or a mining company, and it has been very difficult to negotiate with them because they said, this is our land, so which are the benefits that we are going to obtain? And they don't see that this is going to pay off. So I only wanted to share with you this regarding these regions. Thank you very much. Thank you very much, Madam Magistrate. Please, Mr. Magistrate. I really congratulate Olivia, Panama, Mexico for all your presentations. But in our case, I think that the solution is completely the other way around. In Chile, at the beginning of the 90s, we didn't have this indigenous issue. At least it hasn't been noticed. So the son of a president was devoted to this in some time, and the Mapuches, which are our indigenous peoples and haven't had any kind of problems, and they live between the Tolten and the Vio rivers. So they started this exaltation of their rights, because they have always had them, but this representative that has been elected, and they felt that they were all people from Chile. They were part of the Conservative Party, others were part of the other party. So this started worsening, and an NGO that was funded by European countries got there, and they started experimenting with these people in our country. The truth is that this matter has been escalating. And right now, I would say that we right now have a terrorist, because they burned buses, they rob churches, etc., and they are protected precisely because of the 169 covenant that you mentioned previously, because they wanted to install a hydroelectrical company, for example, but they have to cut trees and lines of whatever. So you can oppose to this, and they were opposing to this, but the country is only one country. So this is of concern in Chile, and we have been observing even now during the presidential elections. There are some candidates that are willing to do this thing of setting out that the indigenous peoples have the rights, to divide the society. And we didn't have this division previously, and this is of my concern. In my case specifically, because they have been dividing the country for something that is absolutely artificial. These are external interests, and they are not part of our Chilean culture. Any other participations? Thank you very much. First of all, I would like to offer an apology to Dr. Sandoval, because I had to go out, because I had to take care of some matters of the organization of this event, and I was not able to listen to all her presentation. I would like, first of all, to set out a very important matter, and this is that we all around this table share something, which is the pluricultural nations that we have. And this is what makes wealthy Ibero-America, specifically the American continent. But of course, this creates huge challenges. And these huge challenges include the conciliation of the world in how to observe and see democracy. And this is a mandate that, at least in the Mexican case, we have the obligation to preserve. To preserve the cultures, to preserve their practices, their traditions, and their customs. So what is set forth in the Mexican Constitution? Well, only one restriction, which is our issue, which is such traditions and customs have to be given with respect to the fundamental rights of all the individuals. So here we have two issues. The first one, which implies their own traditions and customs when we are speaking about matters like, for example, the breaching to the women's rights, or breaching of the people inside the indigenous culture. But also, today we are facing a phenomenon which is before people that are not part of those indigenous communities. So now we are facing the problem in some communities in Mexico, as Magistrate Figueroa was mentioning, where their regional chamber is the one that has the greatest number of dilemmas, because they are the ones that embrace all this circumscription of Oaxaca and Chiapas. But we are facing very complex issues, like, for example, today there are minorities that are not part of these indigenous communities. So here, and as our peer from Uruguay was questioning, if in one municipality we can have two different governments, that's what we are facing precisely. There is the traditional government of this law, and the way to elect the authorities. They don't allow that other parts of the same municipality participate in the democracy because they say that they are not part of this indigenous community. Obviously, there is a very huge burden that regarding all the limitations of those customs and traditions or indigenous customary law, and could be deemed as a breach to this law. So, from my standpoint, our job and our role is to make the society to reconcile among themselves. And democratically, we have to obey or abide by those customs and traditions, but we also need to observe that all people that are living in that cultural space have the right to exert their political and electoral rights. Otherwise, we can be facing an issue that is similar to what Mr. Magistrate Patricio was mentioning, which is discrimination the other way around, you see? Because on the one hand, we have the need for that customs and traditions to prevail, but at the same, because they are guarded by the Constitution, but at the same way, we have to think in matters that have to do with the conciliation and best practices, to sit them on one table and to have a dialogue. And many times, this is a huge dilemma that we have faced, this integration of the high chamber. We have a very complex debate in this subject matter, because almost always we are divided 4-3-3-4, and these are the kind of dilemmas that we are facing nowadays in the municipalities where we have this indigenous customary law. I have mentioned all these things more as a citizen than as a minister. We have never had an electoral issue along these lines, but what I have been mentioning is that from the things that I have been listening here, because I think that it's better to unify than to divide. to bring all the people and to make to make them feel that we are all equal. Because, for example, the southern part of Chile was colonized by German people, so maybe those that are descending from German people, they would like to have some specific right, but they are considered as citizens because we have never had an issue of this kind before the electoral justice. That's what I wanted to clarify. Thank you very much, Mr. Minister. Are there any further comments? Well, so now we will give the conclusions, and I would like to thank you for all your participation. Undoubtedly, once more, we confirm that in the agenda of electoral justice in Ibero-America, this matter of the indigenous peoples has been submitted to the consideration of the legality, topics of very different sizes and once we know all these legal frameworks, they explore the possibility of having access to different rights, such as the possibility of managing directly their economic resources. That has to do a lot with what the magistrate of Uruguay was mentioning, that where we are trying to decide on if we are not creating a fourth level of government. So very soon they will have to pass through the chambers, through our Supreme Court of Justice of the Nation. And finally, I would like to mention also that this constitutional reform of the indigenous customary law in 2001 was sent specifically for the agreement of San Andrés Larraiza. As you might remember, in December 1993, Mexico had an armed movement that was later on a result of several conciliatory meetings, and it was precisely in San Andrés Larraiza in Chiapas where these meetings were held. And many of the topics that were recovered in the constitutional reform of the year 2001 were born there. Not all the topics, but most of them. So effectively, as you can observe, this thing of indigenous customary law, specifically in Mexico, was addressed as a very important topic in the agenda of the tribunals 25 years ago, practically. So we are completely committed to provide for our indigenous people an electoral justice of the highest quality. I would like to thank all of you for your participation. And to finish, I would like to ask Carmen if you please give us your conclusions, Carmen. Thank you very much. Yes. More than conclusion is to make a comment to all the questions that were posed. This process in Bolivia has been present for several years, and of course there has been a lot of incidents, the participation of the representatives of indigenous people. Like, for example, we have as a background Covenant 100 of 69 of the the work international the ILO, and then when the indigenous territories were called the communitary lands, original communitary lands, that's one of the backgrounds. And the other one is that 10 years ago, in 2007, the Declaration of the Indigenous Rights by the UN Assembly. The current member of the Electoral Supreme Tribunal, Maria Elena Choque, is the other member, indigenous member, and has been for several years a representative before the Permanent Forum of Indigenous Peoples, and she has been a representative for Latin America, not for Bolivia only. So these are historical processes that influence in what is happening currently in the world. The specific question of how to have justice and administration and organization at the same time in agreement from the indigenous peoples and the municipalities. In indigenous autonomy regimes, we have two right now, and there are several in process, two current and several in process. So if they become indigenous autonomous regime, then the indigenous government takes office, and then the municipality stops existing. So the indigenous jurisdiction is present in all that territory, but in order to obtain this, they have done several agreements with the population so that the statute is approved, where we have representatives of all the peoples who live in that territory. For example, the Charagua autonomy. We have indigenous peoples that have migrated from the western part, and they live in a specific people, and they have the representatives, and they are not Guaranis. And the traditional Charagua people live there, which is made out of criollos people, and nevertheless they have been able to include that coexistence. So there, the indigenous authorities are the ones that are in office. And in the case of an indigenous territory which is inside the municipality, when it becomes an autonomous regime, the municipality loses that part of territory. That is going to happen in Ragaipampa, where already the referendum was won by the approval of the statute, and we are in the process of conversion. We, as an electoral body, and I would like to clarify this, do not intervene in the indigenous electoral justice. We simply oversee, support, in order to give a scientific opinion, in order to know if they are complying with all the steps that they were proposing, and if they are carrying out the processes as they were intended for, without contravening the Constitution or breaching the Constitution. And another thing, the Constitutional Tribunal checks and follows up in detail all the statutes so that they are not breaching the Constitution. So this is the connection between the administration or management, because it's not only justice, this is the administration, justice, government, self-government, and the laws of the state. That's why we call them indigenous autonomy regime. So this is an experience that, as all new things, is being difficult, but we are achieving it. And every country has their own process, their own experiences and ways. And Ecuador, that is not present, has also made a good progress in this. Thank you very much. Thank you very much, Carmen. Thank you very much, Mr. Magistrate. Mr. Alberto Vivan, thank you very much. And I'm going to give back the floor to Dr. Mara Gomez. Well, thank you very much, Magistrate Luis Sandoval. Thank you very much, Magistrate Figueroa. Excellent presentations. We are going to give you a huge round of applause. Thank you very much. Now, I would like, please, to ask the members of the next panel to come to the table. I would like to inform you that panel number 4, Electoral Justice and the New Challenges for the Political Participation of the Youth, is going to start immediately.